The meeting of the Board Governance Committee will come to order. Do we need to call a roll?
Representing the Director of Finance, Mr. Reyes.
Present.
Ms. Hendricks.
Present.
Representing the State Superintendent of Public Instruction, Ms. Zumot. Representing the State Controller, Mr. McGuire.
Here.
Chairman Lawson, you have a quorum.
Thank you very much. The first item is the approval of the committee agenda and work plan.
So moved.
Second.
All in favor?
Aye.
Aye.
All right. Item number 1 is approved. Approval of the minutes. Entertain a motion to approve the minutes.
So moved.
Do I hear a second? Second. All in favor? I seen some reticence there.
Need some more coffee here. Come
I was
on.
not a committee member at the
It's
time,
almost lunchtime.
so,
All in favor?
Aye.
All right, committee minutes are approved. Mr. Carlin, update on the placement agency policy.
Good morning, committee members. Robert Carlin from the legal office. This item is really just catching up the policy manual to comply with the law and what the practices that staff have adopted based on the law. So in 2011, SB 398 passed. It made a couple of technical changes to the definition of some of the terms in our placement agent policy. So our policy is based on what the law says, so we're just carrying those changes forward here. You can see the really substantive changes to the policy on board governance 27. I think the write-up does a pretty good job of encapsulating what the changes are and why they are being made. So this isn't the only action item for the committee today, apart from the minutes and the work plan. So if there are any questions, I'm happy to entertain them. But otherwise, staff's recommendation is to approve these changes to comply with the law.
Any questions for Mr. Carlin with respect to this? In which case, we'll entertain a motion to approve.
so moved.
Second.
All in favor?
Aye.
Aye.
All right, item is approved. Insider trading policy.
Thank you, Mr. Chair. These next 3 items are potential policy change issues and or policy update issues or policy input issues. We've put them together a little bit differently than we have before because this is something I think that we'd like to hear from us, Board Governance Committee and board members of what their direction to staff would be. We think the discussion front-ending the process would be most helpful. Joining me to help facilitate the conversation, of course, is the board's board governance consultant, Nancy Williams. I appreciate her traveling out here and helping prepare the items. The board's fiduciary counsel, Ian Lanoff, who is also here to provide input and guidance and answer questions. Robert Carlin, who's worked on all the policies and has for some time. And we kind of teed it up with a background of where we are, what some of the governing laws are, a discussion piece, and then we have some discussion questions that we think might identify the issues. And we're hoping to move it along that way, trying to stay on schedule. And I think the chair and other members of the committee have recognized, as we have, that the insider trading policy discussion will probably be the most robust. So we're starting off with that one.
So part of what we provided in the write-up, we have on the insider trading policy, we have some background on an SEC investigation for the retirement system of Alabama, which is one of the first sort of formal applications of insider trading rules to public pension funds. So we think that's relevant, and there's some information there. We also put together a table on board governance 31 that does kind of a comparison between CalSTRS, CalPERS, Texas Teachers, North Carolina State Treasurer, and Ohio PERS. Each has a different type of insider trading policy in place. Some have gone with a personal trading policy. So we put together this matrix highlighting some of the different features in each of these policies and showing where there's crossover and where there's some differentiation, to provide the committee with some examples of what's out there apart from what we have here internally already.
And just for the committee's benefit, we have, even though we have two California plans in Texas, just remember that the the Ohio is really the critical policy and pivotal decision-making. It's an election joke. That's because you're already down into serious business, and not the first time my jokes have fallen on deaf ears.
I mean, in my other life, the public pension plans of Ohio have, I've run into a number of different issues where there's a lot of case law dealing with the Ohio public pension plans, and you don't find a lot of case law with respect to public pension plans at all. So your statement made perfect sense to me.
How lucky for me.
But I think your survey with Florida is not complete yet. Sorry.
We've also provided what we consider some of the issues that the committee may want to consider in determining whether or not we want to make any additions or changes to the insider trading policy that we have right here, including things like we provided examples of material non-public information in the write-up, the sort of things that are typically garden variety insider information, if you will. We provided, we think that the nature and quantity of material non-public information available to different parts of the organization is relevant in determining what kind of changes we want to make, because not everybody has access necessarily to investment information or things like that. And that's relevant in determining what direction we're going to go in. As well as looking at sort of what we provided later on in the write-up, a summary of some of the different types of prophylactic measures that you'll see employed both in the private sector and the public pension funds to try to defeat or deter insider trading from happening in the first place. That's things like pre-clearance policies, mandatory holding periods, blackout periods during which certain securities can't be traded. So there's a variety of different features available that one could incorporate into a policy that may or may not be useful. We're looking for some feedback and discussion from the committee in terms of which of these may have value to be added to the policy. And then we provided near the very end here sort of a discussion guide. You can see that on Board Governance 35 that we think are some of the main issues that would be useful for this discussion.
Ian, did you have any comments you wanted to make in the preliminary comments before we started the discussion?
No.
I will point out that Ian and I did discuss the board item several times. He had he was very instrumental in helping us put this together, and also Nancy Williams and I worked with Robert on this as well. All four of us worked together on this, and Tiffany Vincent, the legal analyst.
I actually did work on every one of those on page 31, except for CalPERS, and including Ohio. So when Brian said that about Ohio, I thought he was serious.
I should have shut up when I was ahead. So, go ahead. I thought I would ask Nancy to tee up the first item of discussion, or the first discussion point.
Keep in mind that we're having this discussion because we want to make sure that CalSTRS is always out there with following the best practices, or even creating the best practices. So we're not having this discussion because there's a problem we're trying to fix. This is just to stay ahead of things. Looking at page 35, you'll see we have a discussion guide of some questions that we thought if we could have answers from the committee to some of these questions, then what we would be able to do is draft up something or make modifications to what you already have in your governance policies and bring something back to you at the next meeting. So this is really food for thought. I think some of these questions would be best answered by the committee members, but also I think that Ian and internal legal staff would have some good answers on these things. So, and I'll certainly share my opinion on some of this too, if you're interested in that. But if we can, then let's just start off with the first question about the current insider trading policy. Keep in mind, you do have that. Is it strong enough? And I guess this is more a question maybe for internal legal staff and Ian. Are there problems that we're trying to address with regard to insider trading that aren't already handled by the federal securities laws? So I guess I would kind of address that maybe to staff first for the committee's benefit, and then questions from anybody else.
I think, and certainly after, I've had a conversation offline with Mr. Lawson and others. Our policy is its own policy. It's not to replace or necessarily to supplement law. It's to provide us with guidance and everyone in guidance on how they should act in order not to violate the law. And so problems that we're trying to address what we're trying to address is to keep or do the best that we can to prevent violations of law by staff, violations either actual or the appearance of violations. The current policy is a policy that really is self-certification. And that does, we haven't had any problems, so we're here to say, and all of us can say, we're not addressing an actual problem. There has not been a violation of the policy that I am aware of at all, and we are not concerned that there is. But what we are concerned about is what policy should we have in place to provide the best protection for the organization, provide the best guidance for staff. I think if you send me away just at this moment to work on a policy, I would probably want to invigorate the training process for internal training. But again, let's certainly open it up to Ian's comments, but we're not reacting to any particular instance or item.
Yeah, Brian and I talked a little bit before we started, and what I was saying is when you create a policy, it depends on how you view a policy. This is one fund. I've been here, a long time, and it's not a place where I would suspect that there's been any wrongdoing or there's even a threat of wrongdoing, unlike some of my other clients, which will go unmentioned. But so do you frame a policy with that in mind, or do you frame a policy based on imaginary horribles? None of us are going to be here forever, and there are going to be future boards, and there could be mavericks who show up on a future board. So is that what you think about when you frame a policy? And I sort of lean towards that myself. And there are three things that I identified and we've talked about amongst ourselves. Really the first question, is the policy strong enough? I think there are three things that you need to think about. First of all, should board members be covered as well as staff? We have a setup right now where the board does not get involved in making, certainly stock and bond decisions. Is there any need for the current policy, which is aimed at stocks and bonds, really, and stocks primarily, to include the board? I represented a fund at one point where I was being told that the chair of the fund, who is a day trader, was spending most of his days down with staff while they were making trades. So was he doing anything wrong? Of course, when he was accused of it, not by me, but by others, he was offended and blah, blah, blah. He later had to resign because it turned out he had failed to pay some gambling debts to Las Vegas and was being sued. So that was the kind of chair we were dealing with. So that's one question I think you really need to think about is, it's fairly simple just to expand the policy to apply to the board. It may never apply to this board because you may never be involved with the decisions that are made internally or by managers. But that's one. Second of all, Nancy raised the issue, which I really never thought about much because I've always thought about insider trading in the traditional way as stocks, as equities, and the securities laws. How about, getting information about real estate investments or private equity investments? And now the board does sometimes get information ahead of time, as does staff. So, we would be an outlier, I think, if we, decided to apply this policy to a broader category than just stocks. But is that something that sounds like it makes sense? So there's not a threat that any board member or staff member is going to somehow figure out a way to use information he or she is receiving about contemplated private equity or real estate, or, I guess if you include hedge funds in private equity. And then the more technical issue, I think, is whether to adopt a pre-clearance approach on equity investments, where before staff or if you would decide to include the board members make certain kinds of investments in equities, they have to go to somebody. At Texas Teachers, there was a pre-clearance officer, and I was being told it wasn't really working so well. The person, at least when I was there at the time this all was raised, wasn't always available, and so staff, was getting frustrated at times when people wanted to make investments that they thought were harmless and not abusive, but they couldn't find the person. And then I was being told by other people that the particular person at that time was too nice and he wanted to get along with everybody, so he really wasn't enforcing the rules maybe the way he should have been. So, you bring in personal, sort of judgments and personalities into it if you set up a system like that. So those are the three questions that I identified that, I would recommend you think about in terms of answering the first question: is the policy strong enough? Is it broad enough? Is it deep enough? And is it detailed enough? I mean, those are the kinds of things that I thought of. And I don't know if Nancy, Brian, and Robert had other ones.
I just, because we're going question by question, I neglected to mention that I asked Chris Ailman specifically to be here and be part of the discussion, as having a lot more substantive knowledge of the types of trading we do. And I just, if I could put Chris on the spot about the pre-clearing. Oh, I thought you were already sitting there. I'm sorry. About his thoughts on the pre-clearing function, having a pre-clearing function.
Well, actually, go ahead. I apologize. Go ahead.
The challenge, and I agree with some of Ian's comments that we've heard from other institutions, it requires additional staffing and adequate communication. The volume of the trading that we do is usually in broad indexes, and that's where then later on in your discussion it becomes a decision of to what level are you screening. If we trade the Russell 3000, we literally are trading about 2,980 stocks. Does that cause them all to be restricted for that day or not? And so as always, the implementation proves to be the challenging part. The devil's in the details. So the few times where we are trading a security that may be restricted, like an IPO that's now being released, those are pretty easy and pretty obvious. Or if we're making an acquisition of something that's in closed session. So part of the challenge with any of those lists is the implementation of staffing and, as was described, availability for staff. I encountered some of, the state of Washington isn't listed here, but we had all kinds of rules back then in the 90s. So I'll share those experiences as we get to it.
Sharon, you had a,
Well, I'm just trying to understand the purpose of this policy in terms of, is it sort of a roadmap for our staff and the board to kind of understand, you know, I guess I'm just trying to understand the purpose of the policy in the first place. Is it to prevent us basically from getting, you know, I invest in Google because I think Google's a good stock, but if Chris tells me in a meeting to invest in, you know, is it to keep us from getting information and making personal profit on what we hear as board members? Is that what the policy is for? Or could you just talk basically about what's the point of the policy?
You hit on quite a few issues in your question. So no, it was a great question. The purpose of the policy is, I see really twofold. One is, as we mentioned, and we'll probably discuss more, is protection of CalSTRS from bad acts by people who are possessing non-public confidential information. It's normally in the discussion, this is where it can get confusing, is normally when people are talking about insider trading, they're talking about publicly traded equity stocks like Google. And if you somehow knew that Google was going to acquire Chick-fil-A, and then you would buy Chick-fil-A stock and you would make money. That's sort of a standard. But that's sort of the standard concern, or if you're aware of some other major thing that would move the market, maybe that there's going to be a lawsuit and that would move the stock. And the other part, so that's one, is protecting the organization. And the other part, of course, is to give guidelines for everyone to avoid violating the law, avoid putting in a position where the organization could be responsible or could have some liability. The difficulty, and that's why this is a difficult conversation, is this is pretty much of a round hole. When you're talking about insider trading policy, that's what you're talking about. You're talking about classic insider information. We're not really that animal. We're a public pension plan that we invest in a lot of things as board members and as staff members, and there's a difference. But there's a lot of non-public information that we are privy to. And that could be used for personal gain. So it would be non-public confidential information used for personal gain. That's kind of a broader definition. And I think perhaps Nancy and Ian will get into some of the more detailed examples. But for example, if you had something in closed session that was, any board member had something in closed session that they saw was a real estate transaction, and we were going to be investing in a development deal in West Sacramento. And so someone saw that and said, okay, hey, West Sacramento, land's pretty cheap. I know we're going to build there. Let me buy some land around that development area. When it develops, then I can sell it for a profit. That's not traditional insider information that people think of when they talk about publicly traded stocks, but it is the kind of non-public confidential information that should not be used for private gain. So we're trying to define a policy that sort of hits some of these other areas rather than just the insider trading policy. And the instance that we cite in the materials, that the only real guidance that we have besides common sense and good lawyering is we have the SEC's report of investigation on the retirement system of Alabama. And there, the issue really came down to one of knowledge and training. Were the people there aware that they had an insider trading? Did they know insider trading policy? Did they know, could they recognize inside information or recognize an insider when they actually got the information and therefore shouldn't have operated on it? Because that particular instance was one where they had inside information and then they went ahead and traded on it and made money for the pension system. So it's kind of unique and certainly nothing that would happen here because they owned another entity, so they had that kind of information. So if there are points of confusion, it's because we're trying to do something a little bit broader than your standard insider trading policy. But I hope I gave you enough to answer the question.
I guess I'm just sort of trying to get at, it's not necessarily preventative. I mean, I would imagine if there's, a board member or staff person that really wants to wheel and deal for personal gain, they're going to do it. It's more meant to be kind of a policy so we can enforce what the lines are. Is that kind of?
Yeah. Yeah, it's like a locked car door. It'll you do the best that you can, but somebody's going to come along and break the window and steal something. They're going to do that. So that's a really good insight into it. That's what we're talking about.
Paul?
Thank you. First of all, I agree that insider trading encompasses a lot more than just publicly traded stocks. I mean, my company has a very extensive insider trading policy, and all we do is work with bonds that do not trade on an exchange. But there's still a tremendous opportunity for having what's called, the standard is material non-public information that affects the value of that security if somebody knew that material non-public information. Also, it's important to know you don't have to make money to be accused of insider trading. In fact, you don't even have to do the trading to be accused of insider trading. If you give material non-public information to somebody who then does use it, then that's a violation as well. So it's a very all-encompassing thing, and the policy of insider trading is to address the fact that it's a federal felony to engage in insider trading. So it's not a policy, it's not of like, well, we just don't want people wheeling and dealing to make money. It's that people have a responsibility not to commit a federal felony by trading on material non-public information. But I guess my question is, given that, my understanding has always been that insider trading is something that is committed then by an individual, and that our general worry is that an individual, be it a staff person or a board member, engages in insider trading for their own, hopefully, or their intention is for their own personal gain. What responsibility, as we look at setting up a policy within CalSTRS, what responsibility does CalSTRS have to prevent insider trading by individuals? Or are we talking also about setting up a system to prevent insider trading for the benefit of CalSTRS? And I don't even know whether, I don't even understand, because I've always thought about it as in personal terms, whether an institution like CalSTRS could be in violation of insider trading.
Well, that's what the Alabama situation was that Brian referred to. I thought Alabama only invested in golf courses located in the state of Alabama. So I was sort of surprised to learn that they were even investing in the stock market. But so the SEC made clear that a public pension fund should not be, doing what they did, which was to use inside information, which they were able to get, and then even for the benefit of the public pension fund.
What responsibility do we have then to prevent insider trading by employees and board members when they do engage in insider trading with the intention of their own benefit?
Right, well, that's the next question, and that's really what you're answering today. But I would say there's two sort of aspects to it. First is what I would call, and what I think you're calling, traditional insider trading, where somehow you come into the knowledge of material non-public information, and then you act on it. So I don't even know how our staff or any of you would get inside information about a public company. But if you did, then you'd violate the law. You'd violate the securities law. Front running isn't necessarily a violation of securities law, but it's something that we would recommend this board still want to prevent. And front running is different. Front running is learning really what CalSTRS is doing. So CalSTRS, as Chris points out, most of your internal operation is not with individual stocks like a lot of other public pension funds. It's indexes. But if you had, if you invested directly in individual stocks of public companies, you're big enough so that if a decision was made to buy or sell a lot of equities in a particular company, it could sway the market. And that's what the concern about so-called front running is all about. And that's not really traditional insider trading, because you're not acting on material non-public information about a company, which is regulated by the securities laws. You're getting material non-public information about what CalSTRS is doing, which I don't believe is regulated by the securities laws. But it's something that, as a policy, you don't want to permit. Right.
How much responsibility do we have to prevent insider trading by our employees and board members when they do that on their behalf? In other words, they're the ones who are responsible if they do it. They're the ones who are committing the crime if they do it. How much responsibility does CalSTRS have to establish policies to try to prevent that from happening?
I would say it does. And,
Okay,
to provide an incubator for people to act in a corrupt way is something that we're recommending the policy address. Yeah. But you already do. I mean, you already have a front-running policy.
In terms of when we think about, do we need to beef it up? Do we need to say more than just self-compliance?
Right.
That, in part, depends on the risk that something's going to happen, but it also depends in part on our understanding of our responsibility to prevent it. So that's what I'm asking is what is our responsibility to prevent
Well,
it?
we're asking you.
Well,
Well, I mean, what do you feel
Whether there's
comfortable
any
with?
legal, whether there's any legal
I
advice
think
as to whether there's.
Yeah, Paul is asking,
Right, I understand.
and it was one of my questions, which is, what I think I'm hearing is, well, let me not put it that way. The question is, what's the organizational liability? You answered part of it with respect to Alabama. The organization should not be engaging in insider trading. That sounds like a fairly easy one. I think the question Paul's asking is, do we have any liability because we didn't prevent somebody from doing it? And I think you answered it partly by saying that to the extent that we facilitate it, as worst case, knowingly facilitate it, and I'd like as detailed an answer as I could possibly give, because I guess, meaning, is there case law or are there rulings or whatever that talk about this? Because I'm not aware of any. That if we simply facilitate it by making it, we know somebody is doing it, and we are somehow deemed to have facilitated it, is one thing. And that's one answer that I think comes out yes, based on what you just said. But I think the question that Paul's asking that hasn't been answered is, if someone without our knowledge, without our cooperation, without our support, engages in insider trading, is there any liability on us for not taking affirmative steps to have prevented that?
And that's exactly what I heard Paul to be saying. And under the federal security laws, there is what's called control person liability, which would essentially be if you allow a person to operate in your organization, and I think the standard is kind of like a recklessness one, but if you fail to take steps to prevent them from doing things that would lead to insider trading, you could potentially be on the hook liable as well. That's kind of what happened with Alabama. Alabama was able to avoid that in part because they disgorged the profits themselves that were made from that transaction. But certainly if we look at the private sector and investment advisors or money managers, they're required under some of the SEC rules to develop ethics policies that deal with what are you going to do, what affirmative steps are you going to do to prevent your staff from either acquiring material non-public information or actually executing trades and profiting on behalf of that. And part of the purpose of all those prophylactic measures is that if that should happen in the SEC or, Attorney General comes in, U.S. Attorney's Office, you can say essentially in your defense as an organization, we have the following requirements. We have a pre-clearance requirement for all trades. We have a mandatory holding period. It's not to say that a rogue employee could go around those things, just like Brian's analogy with the locked car. You could break the car window and still get in, but that you took reasonable steps, given the material non-public information available to your staff, to prevent them from using it illegally. So there is, I think there is some responsibility. The Alabama situation with the retirement system of Alabama is really the closest we've ever seen to a formal issue involving a public pension plan, because we're not governed by the Investment Advisors Act, so we're not required to have a lot of those prophylactic measures in place. But there may be some value to doing those things to prevent something from happening. That's part of what the discussion is, I think, today.
But see, what I think Robert is describing is the way the securities laws apply to traditional insider trading. But there's this additional potential problem called front running, which is not regulated. And there, I don't know how you would compute potential liability if a rogue staff member or board member, gets information about how CalSTRS, plans to invest or disinvest, and then acts on his or her own. At one of the funds I represented, an outside investment auditor was brought in when suspicions were raised that one of the staff was actually making trades in his mother's name, ahead of Texas teachers. I don't know whatever happened with that, but that's what, and I don't know so that's why what I'm saying is that's a distinct transaction that you might wish to address in policy because of reputational risk. Because if a story comes out that the CalSTRS staff is engaged in wholesale front running and people are making, individual, fortunes by getting ahead of, what CalSTRS has decided to do in, making big block investments. Or I presume if they learn what money managers, your outside money managers are doing, contemplating making big purchases or big sales. That's something where I can't figure out exactly what the liability would be, but nevertheless, it's probably something that I wouldn't think you'd want to have happen. So that's a separate category. And one of the things I learned when I first started doing this, maybe 10 years ago, for other funds, was that people really hadn't thought about front running in their policies. No policy at that point that I was aware of even mentioned this problem. The problem was always just straight out insider trading. So I think it's a different category legally. Policy-wise, I could see where you'd want to prevent both. And the pre-clearance process, or reporting processes or whatever, applies to both as well. And I think you need to decide what you're comfortable with in terms of the front-running issue, whether you feel the need, to have someone designated as a pre-clearance monitor so that if staff or a board member decides to make a trade in a particular public equity, he or she needs to report to that particular monitor under certain circumstances, that we would define and bring back to you, that so it's disclosed and someone makes a decision whether this is something to go forward. I mean, the way it's supposed to work is if CalSTRS had the authority to make a big bet on a particular stock, and that becomes knowledge to the staff. And a staff member, in anticipation of CalSTRS making this giant trade, goes out and somehow benefits personally by making a trade for his own account or her own account. The pre-clearance monitor is supposed to, know that that trade is contemplated by the individual and says no. I'm aware of the fact that CalSTRS staff has decided to make this investment or disinvestment, and you cannot make this trade under these circumstances. That's what it's all about. And you have to decide, how bureaucratic do you want to be? How strict do you want to be? Is that, do you think that's necessary? Is it going too far? Is it enough just to have something in writing that says people aren't supposed to do this? And possibly reporting after the fact that they've made a trade, is that enough? Those are the kinds of decisions that, that are policy decisions, not so much legal decisions.
Paul, I don't want to cut you off.
No,
at
I'm
all,
done.
but
I'm done.
I think part of the question that we're trying to get at the beginning is, to what extent are we protecting against legal liability, and to what extent are we protecting against reputation?
Right.
So with respect to the front running, what I'm hearing is that this is not technically prohibited by the law.
That I'm aware of.
And so this is primarily reputation.
There'd be some federal case that could be made for that too, though, if it's insider information.
Well, if it's insider information, but is what CalSTRS intends to do insider information? That's not the kind
Right.
of thing you ordinarily consider insider information.
I think that's a fair statement. When we put in the policy last year or the year before, front running,
A couple of years ago.
the discussion was, it's a possible sort of ethical violation. It's a possible, it could be misuse of material information, but it's not covered, as far as I know, under any federal securities law, front running.
On the other hand, I want to go back to the statement you made, Robert, about companies subject to the Investment Advisors Act being subject to rules that require certain types of policies. Those rules don't apply to us. And is that because the liability doesn't apply to us either, or what? I guess I'm.
No, it doesn't apply to us because we're not considered an investment advisor under the Act. We don't fall within that definition. So if you're covered by the definition of being an investment advisor, you're required to affirmatively create prophylactic measures, which in some cases won't actually prevent insider trading, but they're going to cover, they'll be broader than that. But the idea is, by casting the net so broadly, you'll also be preventing insider trading. So the real requirement is, and it's tailored to the particular type of organization they're expected to tailor, but you're supposed to develop policies that will prevent insider trading from happening.
So to a certain extent, are you, is part of the potential recommendation that we adopt rules similar to that? Similar to rules that would be required under the Investment Advisors Act, in order to achieve that same kind of prophylactic protection?
I wouldn't go so far to say at this point that we're formally recommending that they be adopted, but consider them. Yes, in other words, in situations where a private entity is doing similar things to what we're doing, we think there might be some value in looking at what measures have they enacted, because the fact that we're called something differently if we're doing the same sort of activity may not be material if a violation were to take place. So that's part of what we're thinking of.
Because in fact, because of the controlled person definition, as the Alabama case is saying, the entity itself could still be liable under those same.
Correct. A good example would be if we didn't even have an insider trading policy right now that sort of defined what's material non-public information, what's insider trading, and staff were to engage in that. I could see, a regulator essentially saying, you at least have the requirement to tell people in your organization that, hey, there are these rules out there, you need to be familiar with them, you can't, laws, and failing to do that would be almost kind of reckless. I mean, at that sort of a minimum, that's why I think you see in almost all pension plans, pension funds, they have at least a statement like we have that sort of says, there's these insider trading laws out there, here's what they encompass, and here are the expectations that we have for staff to not violate them and to comply and whatever further measures they may have taken.
Paul, are you?
That's fine.
Terry?
Thank you.
All right, thank you, Mr. Chair. The pre-clearance issue, I think, is potentially very important. And And I think we're going to be addressing this topic, this policy, in subsequent meetings. And I would like to sort of at the next meeting, get some indications of the cost of pre-clearance. Relative, there's maybe only 1 or 2 or 3 pension funds that presently do this, but in the case of just having in-house compliance staff, well, that can be costed out fairly easily. If it has to be some form of information technology IT system that's done, that can be more expensive, but we could find out that cost. We could give a hypothetical to one of the vendors and say, what's the upfront, what's the annual cost? I think this board should have that type of information and what the features are of that type of system. Another issue is we're going to have to get into whether or not there's one policy that covers board and staff, or 2 policies separate, or exemptions of board to certain things. And we're going to have to discuss those topics. That table that you provided on BGOV 31, which lists 4 public pension plans other than CalSTRS that recently have updated their policies, I find it kind of interesting that of the 14 provisions that are in that table, only 3 are common to all 4 of those other plans. When CalSTRS is involved, it's 3, and it's 4 if it's just those plans. Only 4 of those 14 are common to those policies. So in some respects, I think this committee should, provision by provision, go through these and understand them and say, should this be in our policy? Do we want it in this policy? What's the value of that? And how should it apply to everyone or separately, board and staff? I think we need to go through that process. And let's see, actually, the only one that is, of those 14 provisions that the provision exemptions is not in the CalSTRS policy, but it is in all the other 4. So I think maybe that's one that's going to definitely get incorporated into our new policy.
Thank you. Before we move on to the second question, I'd like to get some more information from this panel on the application to private equity, real estate, other private asset investments. And as a precursor that I'd like to ask Mr. Ehlman, one of the essential elements, it seems to me, in terms of putting together a policy, especially a pre-clearance policy, is how much lead time do you normally have before you make a decision? I mean, how much lead time is there? I mean, are decisions made to invest or divest early enough for there to be an issue? In other words, if you make a decision in the morning to divest something in the afternoon, is there any, certainly there's opportunity for front runnings, for example, but what kind of pre-clearance is there? I mean, and I say that from the experience of my own firm, where we had a very vigorous and very vigorously enforced pre-clearance policy that required you to get approval from everybody who had any knowledge about a particular security prior to your making your investment. And you had to get clearance from everybody within that 24-hour period. And if there were 10 people you needed to get approval from and one wasn't available, you had to start the process over again. So by definition, it would be difficult for you to make an investment the same day you heard about something happening. And I guess, and I've heard other pre-clearance scenarios that basically say you can't invest, it's kind of a blackout period, a day before the investment occurs and a day after the investment occurs. So for that 3-day period, you cannot invest in securities that are being either acquired or divested by the fund. It seems to me that 3-day blackout period only works if you've made the decision to invest or divest more than a couple of days before the actual transaction occurs. Is that typical? Is it atypical? Is it, and I may be getting into too much detail, but and maybe you don't answer that question on it, but it seems to me that whole system works because you want to give the market time to digest your transaction before anybody within this system takes their action. The theory being that once the market's digested it, you're not really benefiting from that information, from that inside information. And I guess that works for investing after as opposed to front running is a whole different issue. But if it's one day before, it's just more time, you're at risk, so people feel comfortable that you can change your mind or whatever. With respect to these other assets, the market is private, so your ability to benefit or not benefit is not going to be instantaneous at all. So the 1-day limitation wouldn't work there, it seems to me. And I may be getting too much into the weeds here, but I guess my question, going from thinking about what the possible solutions might be to whether there's an issue at all, I guess to me it comes back to what are we trying to prevent? What are we trying to solve? Who are we trying to protect? How are we trying to protect? And it seems to me that ultimately we're trying to protect the system. We're trying to protect CalSTRS, trying to protect the members of this board from an allegation that we either fostered or failed to prevent something. But with that kind of as a precursor, explain to me what we're trying to prevent in terms of a private security, real estate, something else where the value is not necessarily going to move immediately because of a transaction or an acquisition or divestment by CalPERS.
Okay. You bring up a great issue, which is the complexity of the pre-clearance and blocking periods. It's hard to execute these things, which I think Ian mentioned. The best example I can give you on a private security, since some of the general partners are now public companies, we know, and as you know, the lead time there is very long. We're doing 6 months to a year of due diligence, making a decision that's going through a series of committees. It could be that we're going to invest a significant amount that it would change their assets under management a little, that the market may perceive they're now a more enhanced firm. And so we would know with plenty of lead time when we were going to make that, and then following when it was going to finally become public. Because we may make an investment now, but it would not be publicly announced until 3 months later. Another example I could give you is if we were going to buy a portfolio of apartments, or I'll use a portfolio of malls from Westfields, which is, if it was public, then that may change the value of that stock. And again, in the private markets, our lead time usually is pretty long. You hit it on the head with the index management that we do. We are trading individual stock names, Ian, just so you know. Sometimes we're trading the block of the index, but sometimes it's index names. That is much shorter term. And sometimes that decision to rebalance is made just simply that day. when a stock is added to the index, we're rebalancing all 2,900 stocks. The other occurrence we have is when we get a venture capital distribution. So we've received, like Facebook goes public, we were an investor in that, we'll receive shares. Knowledge about when we may liquidate. We're usually not a substantial owner of the IPO, but when we may liquidate could be useful information to somebody where they might want to get in front of that trade. We know when the freeze period ends, generally our traders know how they want to sell the stock, but you're right, it is still a day-to-day market decision. So there's a complexity of, do you just list that already as a block out, nobody can trade that while we own it and are thinking about it, or do we actually block it right before we execute it? So you hit it on the head. It gets very detailed in the weeds about how you execute this. It touches the non-public information side of it, touches a lot of different areas. And so what lines you want to draw. I think your last comment, I would say that the policy we've always tried to set is one of ethics and as a fiduciary, that you're a fiduciary first to the plan. You know, self-interest is got to be secondary. And that's the tone we want to set at the top that becomes part of the policies and all of that.
I guess a follow-on question that again goes to, I just want to put this on your list of things to think about and not necessarily answer today. But one of the issues that we had looking at the insider trading policy that we had implemented had to do with how do you respond to questions from the outside. If somebody calls up and says, hey, Mr. Lawson, I've got this great stock idea for you. I want you to invest in this. I go through the pre-clearance process. Mr. Yeoman says, no, don't invest in that. Do I call back to broker and say, no, I can't invest in that, something's coming up? I would suggest that our policy also address how people should respond to that as well. I'm not sure I know the answer to the question. I simply didn't take their calls. So shall we go on to the next question number 2?
If I could just jump in here for a minute, I just want to make sure we're aware of the time. We can spend as much time on this as you want to, but I want to make sure that we get something out of it so we bring back something to you that makes sense. So we're almost an hour into this, but, and I know we're still on the first question, but I still have questions about the first question. I'm wondering if this is pushing the committee too quickly, or if you feel comfortable saying, would you like to see something come back to you in writing that takes the spirit of the federal securities laws, which is you're not supposed to profit from non-public material information? Would you like to see us maybe come back to you with a paragraph or two that takes the spirit of those laws and weaves it or weaves in the private market securities, the private market opportunities that Chris was just talking about? And then on top of that, I guess I would also like to ask, would you like us to, even though CalSTRS is not a money manager under the Investment Advisors Act, and CalSTRS is not a corporation issuing stock, would you like us to take the laws that apply to those two entities and make it relevant to the CalSTRS operation? Again, I'm thinking about, 3 or 4 sentences that we come back to you with, so you could look at it. I think it's hard to talk about these things in too blurry terms without us writing something on it. And maybe, by the way, I'm asking the question, you can tell that I'd already like for you to ask us to do this. But I think it might be clearer for you that, what I would hate to see is that this organization would lose its reputation because we did something, and our whole argument is, well, you see, it doesn't apply to us because we're not a corporation, or you see, it doesn't apply to us because we're not under the Investment Advisors Act. We look so much like that I'm trying to think of something that won't be so onerous that none of us could figure out how to comply with it. But it really lives up to the spirit of, you're a big financial institution, and this is how other big financial institutions act because they have federal laws imposed upon them. So I guess I'm kind of asking for direction from the committee on that.
I actually like that approach with the following addendum, that with respect to each kind of regulatory piece that you put in there, that you annotated as to why, or where it came from, how this applies to whomever. It may make it more cumbersome, but I think it will help members of the committee understand the relevance of that particular requirement. And, you know, in its application to us, or its shortcomings with respect to its application to us. And I guess in that regard, one of the things that I'd like you to add to the list is what would be, well, two things. Procedurally, how would we deal with a violation? And what disciplinary tools would we have in our toolbox to deal with somebody who violated those policies? And I presume that disciplinary tool would differ for different people, staff and non-investment staff, investment staff, management, and board. Seems to me those are the four categories.
Okay. I think that would be helpful. So if we came back and said, we think this is a good policy because it parallels what corporations would be covered by under the federal securities laws, or we think this would be a good policy because if you were a money manager, you would be restricted this way. We could tell you the rationale for it, and, okay. I think we can do that. That helps. I mean, I just want to make sure we bring something back to you that's just something you can react to. And I think that does lead us right in then to maybe the second question about should there be different provisions or applications or exceptions depending on, and I think in the discussion guide here, I just put investment staff, other staff, and board members. And I think in earlier conversations with Chris, maybe it's professional investment staff versus some people who work in the investment department that aren't close to this stuff. You know, maybe there's a fourth category there. But in preliminary conversations, I think we see the wisdom of, you'd like the same high standards every place, but different people have different access to non-public material information. And so we should recognize that exists and, yeah.
And I'm open to suggestions as to whatever everybody else thinks, is that the policy should apply to everybody. I think that the differentiation should be in terms of discipline. But on this one, I feel comfortable that you know, we're trying to protect the organization again, and regardless of where somebody is, as was said earlier, anybody can break into a locked car. The fact that they don't organizationally have access to inside information doesn't mean that they won't get it or won't do whatever they need to get it. And everybody should understand that acting on inside information is not something that this organization tolerates. And by the way, the policy, I think, should make very clear that to the extent that anyone violates the existing federal laws or state laws on this, that this organization will cooperate with the enforcement organizations completely.
I think that's missing from current policies, and it'd be nice to have a strong statement like that. I think this is going to be an interesting next conversation about whether it's one policy and separate provisions, because I guess I argue with myself over this, because on one hand, I think the board members are so far removed from the day-to-day stock picking that, gee, why should they have all these restrictions on them? But at the same time, I say to myself, you're board members, you're entitled to know everything that's going on here. You really are entitled. Now, you don't get it regularly because you've delegated this and it makes sense. But if you really wanted to, you're entitled to know everything that's going on in every part of the organization. So.
An opinion of us. my assumption is that anybody who wants to do it can do it, and what we're saying is that you better not.
Did you say Chris?
And Chris, you had your hand up.
Just as a staff person, I was going to request that you, plead with you that you really consider establishing one policy as it stands to the ethical principles, the fiduciary standards, because we really drive home to the staff that they have the same fiduciary standard you do. Even though we report to you and you report out to the members, I want to hold them up to that. The thing I'd ask you to also consider, though, is, as we were discussing with Michael, the implementation gets very complex and very detailed. So it's a little bit forward rather than just insider trading. It gets more into personal trading. But a good example there would be, I don't mind if you guys like to day trade, and maybe, you know, I see Pedro up there sometimes pounding away. I know, yeah. Then you must be doing great. But I do want to have a holding period standards, those kinds of standards for the staff, because we have a lot of great equipment, you have a lot of access to good information. We've often joked about it. If the staff won the lottery, a lot of them would quit, but a lot of them would come back to work because it'd be a great place to run their own money. And I don't want to have staff spending time running their money when we're paying them to run STIR's money. So think about one policy, but two different forms of implementation. Because it also, I know from experience, it gets very hard if we create a restricted list for you to be calling into us all the time and us to be able to properly communicating back to you. Picture like on the trade desk when they're trading something, you're not going to see that. I agree with the comments. You have visibility on everything, but you're not going to be reported minute by minute of what's going to go on the trade desk, so you're safe from worrying about your personal trading, whereas the staff in-house would know, and I'd want them covered by the policy. So,
My counter to that is you're saying if everybody played by the rules, we wouldn't have access to that. And I guess what I want you to consider, we're not setting the policy now, I want you to consider whether the policy should be, you know, kind of one size fits all to address the possibility. Because the question is, who are we trying to protect against? Who are we trying to protect? And it seems to me we're trying to protect the organization against an allegation that we facilitated something when something happens. Because this policy will come into question when the SEC comes knocking at Pedro's door. And so,
When?
That was not if.
and then the question is going to be, well, why did you have a different set of rules for him, even though, you know, somehow he got the information? It was not expected. It was not within the normal chain of communication, but he got it anyway, or we are at least alleging that he got it anyway. Again, something for consideration. Please, in your annotation, address why, and understand, you started off this conversation saying you wanted to hear our recommendation. I think what you're hearing is our concerns, our thoughts, but we really need you guys to give us your considered recommendation and the rationale for that recommendation, and we can respond to that.
Yeah, that's great, actually. We did want to, we didn't just want to go off and start with nothing, with no indication of your thoughts and your concerns. So this is great.
So we're at noon. We have two more policies to discuss. Shall we break for lunch and then come back and do it? Because we have until, what, 1:45?
Benefits is at
Pardon me?
2, right? Right, so we can go.
Michael, Mary had gotten a hold of me and asked me when I thought we might be breaking.
Mm-hmm.
And I said, I didn't think we'd be breaking until 12:30, I'm sorry.
Oh, don't apologize. That's fine. So let's spend 30 minutes on the next policy.
I thought we were on a roll there.
So we go to the next item, or is that?
I think we have enough direction that, I mean, there's a lot of work that's coming just from what we heard here today, so I think enough to keep us busy for a while on that.
Usually you got through some of the fork of the road questions that'll let you to do that drafting, or it just, okay. Okay. Yeah, I know, yeah.
I think some of that will, based upon the direction that I heard, some of that will still be in the annotations. It's in here because this is what we're thinking, but the pros and cons will be in there so that a board, a committee member could look at it and say, okay, I see that, I don't agree with the justification, I don't think it should be in there. So I did hear how to construct the deliverable for the next meeting. I think that will deal with the remainder of these questions.
And I don't want to say, Chris, your brief explanation of how you guys work is extremely helpful. And to the extent that some of the policy recommendations are driven by that, it would be helpful to flesh that out to the extent that it's appropriate.
Yeah, and I didn't hear anyone had a need for any more benchmarking information. Usually we start there, and that was the reason for picking those systems that Brian and Robert put in there. But are you comfortable that we proceed then and more just looking at what we're going to do at this point and not delve into the other systems? Okay.
Yep.
Okay.
Okay. Thank you.